Control District Board, item 8 and 9. Move the items.
Mr. Chairman, to divide the question.
Okay, certainly. I withdraw my previous motion and move item number 8.
Second.
Motion and a second. Supervisor Miller, was that the one you wanted to talk about?
Yes, Mr. Chairman. I reviewed this one, and we originally, back in 2017, approved a $5 million contract with 4 amendments for $5 million each. And if you read through the procurement director's memorandum, she talks about how she approved $5 million in Amendment 1 in 2018 and Amendment 2 in 2019 for $5 million, and then speaks about another amendment April 2020 for $5 million. And then today we're approving the 4th amendment, which is $10 million. So there are a couple issues I have with this one. Number one is that the total not to exceed on it is now $30 million, if I add those up correctly. And there's also no more renewals on this because the documentation says there's 2 more renewals. So this was originally the contract plus 4 renewals, and when I reviewed this, it appears they're all used up. So I wanted to clarify that we're now up to $30 million on this, including the $10 million that we're approving today. And also, I'd like to know why the procurement director is approving $5 million amendments. Shouldn't those be coming back before the board?
Ms. Zuckerberg?
Yes, Mr. Chairman and members of the board, this particular contract, and again, I think the answer to the first question is it's the way the contract was written that allowed the procurement director to authorize an increase, and I believe it's important to remember that these are flood control district contracts that have been in place since 2017, and the previous funding has been spent to primarily secure the flood capacity of the major river system. What this amendment does is give the flexibility to respond rapidly if there happens to be any major flood events as a result of the increased susceptibility due to the Bighorn fire. I think it's also important to note that this is a job order contractor concept, and so you have a whole series of contractors who are all qualified and been through a qualification process to perform this type of work. Once a project is identified, the flood control district delineates the scope of the project, and then it's bid against all of the eligible contractors, and then the low bid is what's actually awarded.
Supervisor Miller?
Mr. Chairman, the concern I'm having here is that, number one, it says we have, and I have no issues, obviously we're going to have to respond to flood issues with the Bighorn fire, but that we have documentation that states that we have 2 more renewals on this when in fact we don't. And also it says the not to exceed is $25 million, and according to what we've approved so far, it's now at $30 million. So I wanted to make that clear, and approving amendments of $5 million, as far as I understand, does not fall within the jurisdiction of the procurement director, or it shouldn't, for sure. That should come back before the board because her authorization, I believe, is $250,000. The last that I looked at the policy. So that really concerns me. I hope it concerns other board members. And I do understand this is an ongoing contract, but I think we need to ensure that those come back before the board. That's $5 million. That's a lot of money.
Ms. Zuckerberg?
Yes, Mr. Chairman, what we can do is research the issue about whether or not there are any more amendments, and we also will research the issue of the procurement director's authority and provide that written information to the board. I think the most important concept here is to get the expenditure authority to contract with these contractors who are all qualified under the job order process so that we can accurately and rapidly respond to flood conditions that may arise. Obviously, it hasn't rained much in Pima County, but you never know. It could very quickly. And if it happens to be centered over the Bighorn Fire area, we will need this capacity to respond.
Mr. Chairman, I would like to, for the record, just identify the document. It is a July 13th, 2020 memorandum from Mary Jo Furphy, and it's the second paragraph where she discusses what has been approved to date. And then it is the third paragraph, the last sentence, where it says this agreement has 2 remaining annual renewals. So it is that document, her document, to the chair and the board. Thank you.
Thanks, Supervisor Miller. Anyone else? Hearing none, there's a motion on the floor to approve item number 8. All those in favor, please signify by saying aye. Aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Moving on to item 9. Chair will move the item. Motion and a second. Any questions, comments? Hearing none, all those in favor, please signify by saying aye.
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 All those opposed, please signify by saying nay. Ayes have it. Moving on to Library District Board, item number 10. Second, there's a motion and a second to approve item number 10. Any questions? Hearing none, all those in favor, please signify by saying aye.
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 All opposed, please signify by saying nay. Ayes have it. Moving to sitting as the Board of Supervisors, item number 11, consent calendar. Are there any items that any member would like to take separately?
Mr. Chairman,
Supervisor Christie.
I'd like to pull item number 31, please.
Hang on. Item number 31.
Mr. Chairman,
Supervisor Miller.
I'd like to pull item 14, 31, 32, and 33.
All right. Anyone else? All right, so Chair will move the approval of consent with the exceptions of 14, 31, 32, and 33. As amended. Is there a second? Motion and a second. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Item number 14, Supervisor Miller.
Mr. Chairman, this was an item that has been approved previously for Davis Monson to do their economic development activities, and I believe that if we are going to take responsibility for that, we should be using the employees and the funding within our existing economic development department. So I will be voting no on this item.
Any other comments? Hearing none, I'll move the item number 14 for approval on consent calendar. Is there a second? Second. Motion and a second to approve item number 14. All those in favor, please signify by saying aye.
Aye. Aye.
All those opposed, please signify by saying nay.
Nay.
Motion carries. Moving on to item number 31. All right. Was that Supervisor Christie? Was that your item?
Yes, Mr. Chairman, I have a number of questions on this particular purchase amount regarding some property on South Toole Avenue. It is my understanding it's going to be designated as a kind of a centrally located distribution point for personal protective equipment to the tune of about $3.365 million. At this point, is this property being leased out to any other entity?
Mr. Huckleberry.
Mr. Chairman and Supervisor Christie, yes, I believe there is a lease to Vector Space.
And are they paying any portion of the current lease, or what is their status as far as the lease is concerned, payment-wise?
Mr. Chairman and members of the board, their current status is that they are leasing with the current owner. If the county were to acquire the property, They have made a request to modify their lease, reduce the space, and to pay market rent for a period of 1 to 2 years as they then contemplate building an additional facility. So at this point, there is no agreement between the county and Vector Space for their continuing use of the building or any portion thereof.
Okay. At this particular point, it seems to me that there's adequate facilities throughout county property, particularly maybe over in the juvenile detention center or some other county property that could, in my estimation, house what is being purposed for this property. It's another element of the county buying up property that I don't think is appropriate, and consequently, I will be voting against this this motion.
Mr. Huckleberry?
Yes, Mr. Chairman and members of the board, the county reviewed all of our available properties with regard to additional warehousing and particularly additional warehousing needs for our health department given the COVID-19 pandemic. None of our existing properties had any of the necessary capacity to provide the space needed during the pandemic. In addition, we then examined a number of vacant properties or properties that were on the market that had this type of warehouse capability, including, and most importantly, the ability to provide some refrigeration capacity for vaccines. And this particular site is the only site that met all of the requirements to provide a facility for the health department. In addition to that, we looked at, through facilities management, whether or not we could construct an additional warehouse where the current warehouse is for the health department at the Apache Business Park, as the county does own property there and could construct an additional warehouse. The cost of constructing the warehouse to the same general size as this acquisition is over $9 million. Therefore, we felt that this acquisition was the most appropriate thing and have recommended that we proceed with it.
Supervisor Miller?
Mr. Chairman, I have several questions, and I will definitely let you know when I've finished them. The first question I have is, there is, throughout this agreement, there are references to the Vector lease. Then there are statements that says they're on a month-to-month. And as we know, Vector is in bankruptcy proceedings, Chapter 11. And I would like to ask the county attorney, do they or do they not have a lease with the current owner of this property?
Ms. Huckleberry?
Mr. Chairman, and then I'll let Mr. Flagg answer. They have a lease, and the lease is based on the present property owner a month-to-month. And because Vector Space did not agree to a continuation of the lease of the entire property, which was the original owner's lease, and that's the Levine family with Vector Space. Vector Space is in bankruptcy. The individuals who have purchased the bankruptcy assets are those that are repositioning Vector Space and reducing its footprint. And the present discussion is, if the county were to acquire this property, the lease negotiation would occur with the person who is purchasing Vector Space out of bankruptcy. The only discussion that we've had with them is that their space utilization will be approximately 1/3 of what they're in today with the entire facility, and that whatever the rate is, it will be at a market rental rate.
And now I'd like to ask the county attorney, in your opinion, is there a lease agreement in place with the current owner of this property?
Mr. Flagg?
Mr. Chairman, Supervisor Miller, I have not seen the underlying documentation on this. One of our lawyers handled the legal review of this agreement. I don't believe there are any legal issues with it, but I can't answer that question in any detail because I haven't looked at it myself.
Is it possible to get that attorney to answer the questions today? They should be here if they're the ones that reviewed it, so that we can get these, because I have a lot of legal questions on this item. You know, the fact that there are statements that says they do have a lease, then the lease is no longer valid. It's just a month to month with a 30-day notice. If there is a lease in place, aren't they required to report that to the bankruptcy trustee?
Mr. Flagg.
Mr. Chairman, Supervisor Miller, of course, if there's a lease in place, that's going to be dealt with in the context of the bankruptcy. In terms of your prior question about can I get the lawyer who handled the review of this, I can try to get in contact with him. I will say, I mean, there are a lot of items on the agenda. I've had a lot of different lawyers look at stuff. I can't have everybody available for the meeting, but I can certainly try to get in touch with them.
It's very concerning to me that there is conflicting language, that in one place we do have a lease, then we don't have a lease. And quite frankly, the using COVID funds to purchase this building and then lease it out to Vector Space after the fact, would that be a legal use of COVID funds according to that grant that we've been given?
Let me ask Mr. Huckleberry, please respond, and I'll call back on Mr. Flagg.
Yes, Mr. Chairman and Supervisor Miller, to answer the question on the lease language that's in the document, there was a lease. The lease was in place. It was in place until, I believe, about the middle of December, and then it was allowed to expire. In other words, they had a renewal period, and if they did not renew the lease, it expired. So that lease has expired. They then negotiated with the present owner a month-to-month extension on that lease pending this acquisition. So that's the status of the lease. With regard to COVID-19 money, we are not purchasing this facility with COVID-19 money. We are purchasing it with the general fund that will basically have as part of their origin perhaps anything that's in the ending fund balance, but the ending fund balance is being increased through the reimbursements that the county is getting from COVID-19 from our general fund expenditures. So the purchase of this facility is from the general fund.
Supervisor Miller.
Yeah, and you're co-mingling the COVID-19 funds in there. Okay, I understand that. And under this lease agreement, why would we even want to have Vector in there? We have an urgent need to store the PPP or PPE, according to what you just said, and you discussed a $9 million building to build a building that could hold this information. Why would we even want to have Vector Space in there? They've already defaulted on one lease.
Mr. Huckleberry.
Yes, Mr. Chairman and Supervisor Miller, it is because with the combination of our space at the Apache Business Park and the additional space that will be available here will meet our needs in the short term. And the issue is Vector Space, they can either, when they were purchased out of bankruptcy, the purchasers came to the county and were willing to basically, and this is again their choice, move their entire operation back to Pennsylvania. When they were here looking at the various advantages to retaining their balance of Vector Space assets in Pima County, they decided to do that. And so therefore, if in fact we can accommodate them in a fairly short period of time, which is 1 to 2 years, as they then plan their exit from bankruptcy and staying in Pima County and building another facility, it just made good sense from an economic development perspective to continue to have them in Pima County.
Well, this doesn't make a lot of sense to me that Pima County's out competing with the private sector commercial developers by acquiring buildings to lease to them. And this lease agreement seems to me, I mean, this whole thing, if we are purchasing this for using it for storage of protective equipment, and that we're going to lease it to Vector, That does not seem appropriate with those funds, and commingling those into the general fund, I don't think gets us out of that obligation. And then the statements about whether we have to ensure before we take possession that we have to make sure that the vector agrees. Why aren't we obligating the seller to have vector removed prior to taking possession of the property, prior to executing sale? They're putting that on us. And I don't know why Pima County is taking on that responsibility of making sure that Vector should be vacating the premises if we're purchasing this truly to store protective equipment. The whole issue with the east, I would like to ask the county attorney to get back and explain, because they go back and forth about as if there's a lease in place, then they say it's month to month. So there is in fact no lease in place. And just want to get to my final questions. One of the things in the flat note on section 9.4, the government approvals in the contract, it says the seller agrees to obtain all government approvals required to close the sale. One of the plat notes is that there is a community association required to run the sewer. And we're getting a waiver from the owner, from Levine, that is not in place, that association to run the sewer. However, there is still a plat note in there from I assume it's the city of Tucson, that there must be a community association to run the sewer. What are we doing from a perspective of a legal perspective? Are we bound by that? I'd like to ask the county attorney.
Mr. Blake.
Mr. Chairman, Supervisor Miller, any plat notes that are applicable to the property would continue to apply, and they would either govern or they would have to be modified, or, I mean, I don't know. I guess you'd have to go to the city and see what their interpretation is of that. But it would pass along.
Right, right, and that's my concern, is that we're going to be bound to this by the city of Tucson. We have that the owner assures us that there is no such community association in place, but that plat note is still in place. So have we taken care of that? To get a release from the city of Tucson to release us from the obligation under that plat note?
Let me ask Mr. Huckleberry. Mr. Huckleberry?
Yes, Mr. Chairman and members of the board, I think you need to remember that the Pima County Wastewater Department operates the regional public sewer system, and that private systems connect to the public system, and therefore the note really applies to Pima County, since the city of Tucson does not operate the sewer system. And this is not unusual. In many cases, in developments, the county has a number of buildings that operate, particularly in areas that are surrounded by similar uses. Many of our libraries that operate, for example, at Bear Canyon, the one at Duesenberry, they're all on common privately operated sewer systems that then ultimately discharge to the public sewer system. So the note is really not applicable, and it is our call as to whether or not it's not enforceable against the county, since the city does not operate the sewer system.
So we would, the Pima County is the one who added that plat note to this agreement. Is that what you're telling me? Because the city of Tucson doesn't run the wastewater?
Mr. Ogilvy.
Yeah, Mr. Chairman and Supervisor Miller, that plat note goes with the original subdivided property that probably occurred, a decade or so ago, and was done under whatever standards were applicable at the time, and it was processed by the city of Tucson. So the note was the city of Tucson, but because the county operates the sewer system, it's really applicable to the county. And in the case of private sewers, it's really applicable to our Department of Environmental Quality, such as the private sewer systems are regulated by the local departments of environmental quality or the state Department of Environmental Quality.
Well, overall, I think this agreement, first of all, I don't believe we need any further space. We have properties, we have libraries that are not being used. We have the Fleet Services building. We have the Department of Homeland Security building that was remodeled and is a $115 million building. That was remodel done under the 2004 bonds. Libraries, Fleet Services, we have buildings everywhere, and Pima County should not be buying another building. It requires maintenance, operations costs, and to accommodate Vector. This just seems wrong, especially after they defaulted on a lease to begin with. I think this is strictly for the Vector Space Company. Thank you.
All right, any other questions? If not, I'll move item number 31 for approval. Motion and a second. All those in favor, please signify by saying aye. Aye.
Aye.
All those opposed, please signify by saying nay.
Nay.
No.
A motion carries. Moving